So good afternoon everybody and welcome to the Trinity Long Room Hub and to this Adapt Centre event, the latest in our series of guest lectures, and we're delighted to welcome Professor Chris Kuner here from Brussels. Chris is Professor of Law at the Free University of Brussels, where he's co-chair of the Brussels Privacy Research Hub. He's also a visiting professor at various institutions including Cambridge, the London School of Economics and the University of Copenhagen, and in addition to that he's a distinguished practitioner and he's currently Senior Privacy Counsel with Wilson Sonsini's office in Brussels. Data protection issues are now very much in the limelight, particularly here in Dublin. Ireland has become a focal point for many data protection issues that affect us here in Ireland, across the EU, but also more broadly affecting the EU's relations with many other states, none more so than the US. But before these data protection issues, and in particular the question of international data transfers, when and how our personal data may be transferred to other jurisdictions, before all of this became sexy, before it went to the court in Luxembourg, before it gained front page coverage in the New York Times, there was one very distinguished scholar and lawyer who was reflecting deeply on these issues, and that is Chris. And so it's a real privilege and pleasure for us to welcome Chris here today to speak about EU data transfer regulation. Reality and Illusion is Delusion is the title of Chris's paper, and without further ado, I'll hand you over to Chris. And Professor Owen O'Dell from the Law School is kindly chairing this event. Chris is going to speak for between 30 and 40 minutes, and then there'll be time for questions and answers. And I know there are lots of people who are working on these issues in the room, so we look forward to a lively discussion afterwards. Chris.
All right, well, thank you very much for that very kind introduction, David. You've obviously memorized my biography. I don't know if I could rattle off all of my affiliations by memory the way you could, so that's impressive. And I have to say I'm very pleased to be here, very honored to be here, and that there's such interest in this topic. I'm going to speak for about 30 to 40 minutes. I'll try to be err on the side of brevity and keep it maybe closer to 30 to leave time for questions for you. I don't have any PowerPoints because I generally don't believe in using them unless I absolutely have to, so I apologize for those of you who are used to them. I'm not going to use them. I should also say I have no interest, no interest as a lawyer or pecuniary interest in the Schrems litigation. I know Max Schrems, I like him. I also know people at Facebook, I like them. So, but I'm not involved in the case at all. I'm a sort of bemused, interested observer. I'm going to try to stay away a bit in this talk from going too much in depth into some of the legal issues. There are a lot of legal issues in this that are raised by data transfer regulation under EU law. They're very, very interesting, and it would be possible to fill out a whole course about them, but I don't want to do that here. So I will touch some of them maybe, but skim over the surface a little bit on some of them. Now, I don't need to explain to you what this talk is about here in Dublin, the Schrems case, and beyond the Schrems case, the broader issue of regulation of international data transfers under EU law. It's been in all the newspapers. I know here in Ireland you're really directly affected by it. There have been all sorts of reactions to this case, and it's not just one case, but there is an ongoing sort of continuation of the case now, which has been referred to as the Schrems 2 litigation. I'll probably use that term too, involving the EU standard contractual clauses. But the case has spawned almost a whole industry of data protection, writings, conferences, workshops, everything you can think of, statements by the top US officials, a lengthy press interview by the President of the Court of Justice about the case, which I don't know if that's ever happened before. That was surprising. All sorts of other reactions. So it's a very timely topic, but it's also very interesting to those of us interested in EU law and data protection law. Now, this is a topic, I think all of us who write about this are kind of despair, because it's never a topic which stays still for a moment. It's changing constantly. And there have been other developments since the Schrems judgment. In particular, there was the EU-US Privacy Shield, which came into effect on August 1st, which is a kind of replacement of the safe harbor. And then there was an EU Commission adequacy decision on that of July 12th. And of course, we have the EU General Data Protection Regulation, or the so-called EU GDPR, which will take effect on May 25th, 2018, and will replace the directive. And there's also this another directive, the police directive, that comes into effect with that, but I won't talk about that. So this is a moving target. Things are changing very quickly, and I have to try to, I think, to make sense of this, try to step back a little bit and look at all of this from what I call the meta level. So we'll go into detail, but I want to look also at the higher level and say, what can we learn from all this? What lessons does it teach us? Now, I've taken my inspiration for this talk actually not from data protection law, but from a wonderful short story by Anton Chekhov called Gooseberries. And there's a wonderful quote in there which says, "Dearer to us than a host of truths is an exalting illusion." And I take data protection regulation under EU law as in many ways, a kind of illusion. It's a beautiful illusion to many of us in Europe because it conjures a world where data protection authorities are running around the world enforcing our rights, and we're using standard clauses to protect data, etc. But I think a lot of it is really illusory, and it really gets down to being a matter of politics in the end. And you'll see at the end, I'm going to come back to this as a conclusion, and I'll attempt to show this a bit in my talk. I'm not going to give a detailed description of the facts in the Schrems case because I'm sure many of you know it probably better than you would like, and it's been discussed ad infinitum. But very briefly, it involves the Austrian privacy activist and student Max Schrems, who brought a case against Facebook. He had to then go to the Irish Data Protection Authority, and this gave rise to a long procedural history. And what's relevant for us here is the fact that the Irish High Court then eventually referred two questions to the Court of Justice in Luxembourg. And this was really the genesis of all of the developments I'm going to talk about. The court gave its judgment on October 5th of last year. It was something all of us in the data protection community were really sitting on knife's edge waiting to see what this judgment would be, although I suppose after the Advocate General opinion it was fairly clear. The court found that the EU Data Protection Authorities, or DPAs, had the power to examine claims relating to the adequacy of data protection in third countries, notwithstanding a formal decision by the European Commission that a country was adequate. And this is based on Article 25 of the directive, which prohibits data transfers to third countries unless certain conditions are followed. One possibility for allowing transfers is if the European Commission has given a formal decision of adequacy. And this was the case with the US Safe Harbor. The Commission had said, we find this to be an adequate level of data protection. And the court said, notwithstanding this decision, the data protection authorities may still question and look at the level of protection. And then they also found, as a second finding, that the adequacy decision underlying the safe harbor by the Commission was invalid. So this was the biggest thing ever really in data protection for the last 15 years. I suppose the Google Spain judgment was also a kind of tidal wave, but this is really major development. And it's really, I think, taken a while for it all to sink in, because at the beginning there were many political reactions, and there were US people went completely crazy about it, and EU people were defending it, and now I think that the waters have calmed down a bit. As I said, I'm not going to go further into the details of the judgment, but I do want to mention four themes that the court really emphasized in the judgment, which are very important. One is a strong affirmation of the right to data protection. And in this, the court was building on other recent judgments, for example, Digital Rights Ireland judgment, Digital Rights Ireland and Seidlinger, which is the kind of, I think, become a kind of seminal first case where the court really, under the Charter of Fundamental Rights, strongly affirmed the right to data protection. And also, very interesting for all of us in EU law, that the court found that the generalized access to data by public authority compromises the essence of the right to private life under the Charter of Fundamental Rights, which is it's kind of like the atomic bomb of fundamental rights law, when you find that the essence of a right is violated. There's no balancing or anything. So this was a big finding. Secondly, the court applied or made it clear that EU data protection rights apply to data transfers to third countries. The court, I think, walked a very fine line when they said we're not judging directly the level of protection in the U.S., but we do find that regulatory decisions or legislation that regulate the transfer of data to third countries do have to comply with the Charter of Fundamental Rights. Probably we sort of knew this already, but just saying this so explicitly was very significant. Third was the role of the DPAs, and the court really elevated the role of the DPAs. You could see this in a way of the DPAs going up in status a bit and the European Commission coming down, because the court said DPAs may, and in some cases must, use all due diligence to examine claims with regard to the transfer of personal data to third countries. And the court also said the legislator and the member states then must also give individuals rights to appeal these decisions to court, and then the national court must refer the question to the Court of Justice. So the court sort of created a mechanism whereby there's the individual complains to DPAs about, say, some data processing in the U.S. or data transfer to the U.S. or some other country. It's not just the U.S. Then they go to national court, and the national court refers it. And this was quite striking too. And then finally, the court finally answered the question, what is an adequate level of data protection? Because this is used in the directive, the current Directive 95/46. It says you may only transfer data to third countries when there's an adequate level of data protection. But what is that? What is an adequate level of protection? And the court finally came out and gave a definition. They said this is a level that is essentially equivalent to the level under EU law. So this is quite a high standard. I suppose essentially equivalent is not exactly the same as being identical, but it's close. I mean, it's maybe not identical, but a little bit below that. So it's quite a high bar that the court set. Now, let's talk a little bit about what the effect of this judgment has been, because this has really wide-ranging effects far beyond just this particular case or this particular adequacy decision. Everyone talks about data transfers to the EU and the US. I think people forget that in the greater geopolitical scheme of things, if you look at all of the different predictions by economics institutes and academics, it seems, the US is going down over the next few decades. Asia and other countries are coming up. There's a huge amount of data being transferred to India, to China, to other countries. So this is not just about the EU or the US, although you might think it is about the US because it's only what's really talked about. Another interesting point here is the effect of the judgment on the privacy shield and on the GDPR, because this would be one thing if we had the directive, if this was going to continue in force for the next few decades, then you could just fix the safe harbor judgment and done. But we're going to have a completely new framework for data protection, and it's massively different than the current framework, much more complicated, many more obligations. It's really a totally different concept in many ways. So I think it's logical to say, how do these other developments play into this? Well, the privacy shield, as I said, came into effect on the 1st of August. There are now quite a few, I think several dozen US companies have signed up to it, including some of the large internet companies, and probably there will be quite a few more signing up to it. The basic construction of the privacy shield is similar to that of the safe harbor. And it's a set of principles which is derived from EU data protection law, but is somewhat watered down versus EU law, which companies can voluntarily self-certify to, and compliance with is policed by the US Federal Trade Commission, which is a kind of consumer protection regulator in the US, and also by other self-regulatory dispute resolution mechanisms. One thing that's striking to me about the Privacy Shield is the degree of secrecy that marked the negotiations between the EU and the US. You would think this was a matter of major security of the world, that it was really kept very secret. In fact, I know a number of US companies were not happy because they also they weren't given much information about the negotiations. And there have been, since it's been approved, there have been some interesting opinions issued by the Article 29 Working Party, which is the group of all of the EU, of all of the member state data protection authorities, and by the European Data Protection Supervisor, which is the regulator for data protection at the EU level, who, let's say, expressed doubts about its compatibility with EU data protection standards. So there is a bit of a cloud hanging over the Privacy Shield, but it is out there and it is running. I also think the GDPR will raise a number of issues with regard to data transfer regulation and the Schrems judgment. The GDPR contains more or less similar rules regarding data transfers as the current directive does, but with a lot more detail and a lot more complexity. But other than data transfers, it's really a totally different animal, much more complicated. And of course, it's a regulation rather than a directive. And we know under EU law, regulation requires no implementation; it just applies directly. In fact, you can even ask, is it even possible to have implementation? So we will get this, and it will apply directly. And this means in member states now, I know a number of ministries of justice are now working on revising their data protection laws, because there will be no need for a national data protection law except for areas that are not covered by the GDPR, or areas where the GDPR leaves room for national differences. So it seems to me that the fact that it's also striking that GDPR contains rules in a number of areas which are not contained in the current directive. So data portability, privacy by design and by default, etc. There are quite a few of them. And so I'm struggling to decide for myself, can the current Privacy Shield, if it's based on the directive, still be considered essentially equivalent to EU law if EU law has changed dramatically? What will happen to the Privacy Shield in May 2018? There's also a little known footnote. I don't know if anyone's found this footnote. Look at footnote 140 of the Commission adequacy decision of the Privacy Shield, and it says, as of the date of application of the GDPR, the European Commission will make use of its powers to adopt and implementing acts suspending the present decision, which, just based on the English, the meaning would say, okay, they're going to somehow repeal the Privacy Shield, and I don't know how that would work either. So I think there's a lot of uncertainty hanging over the Privacy Shield, also because of the GDPR. I want to also now talk, and I know I am going through very complicated topics fairly quickly, but I want to talk a little bit about the effect of Schrems on the other data transfer mechanisms under EU law. This was an immediate question many people had when the Schrems judgment came out. Okay, the court has set very strict new rules for adequacy decisions by the Commission, but what about the other methods for transferring data? Are they affected? Now, I'm taking as a starting point the fact that under the principle of the rule of law, there must be the consistent application of legal rules to similar situations. I think that's a given. And certainly the court has been striving in its case law to provide coherence with regard to existing case law predictability and avoidance of arbitrariness, etc. So keeping all this in mind, you might say, what is the what does the Schrems judgment mean for other means of data transfer? Well, I do think that there are three different levels of standards that are required under the three different mechanisms for transferring data. So the highest are adequacy decisions. The court has said this must be essentially equivalent to standards under EU law. Just below that, there's what are called adequate safeguards, or these will be called appropriate safeguards under the GDPR. And this means, for example, standard contractual clauses or binding corporate rules. Binding corporate rules are sort of internal company codes that companies adopt with regard to their data processing. Contractual clauses are clauses that a company in the EU which is exporting data signs with a company outside the EU that's importing the data, under which they both agree to give certain protections to the data. Then we have the third, the lowest level, which are the derogations, where the legislator has said even though there's no adequate protection or there's no adequate appropriate safeguards, we will still allow data transfers to go forward. For example, consent. So if an individual says, I know there's no adequate safeguards in Afghanistan, but I want my data to be sent there because my brother is working there as an aid worker, it would be strange not to allow that. So we do allow that based on consent. It seems to me that it's certainly the case that the fact that one of these mechanisms is invalid doesn't necessarily invalidate the others. So if you say the safe harbor doesn't provide essentially equivalent protection, that doesn't mean that you can't allow data transfers by standard clauses which have a lower standard. However, I also think that if a criticism of an adequacy decision can be applied by analogy to other legal bases for data transfer, then this would seem to raise questions about these other bases. So just looking at these different three bases, we have adequacy decisions. The safe harbor is inadequate. Well, it happens that there are adequacy decisions for two of the members of the International Five Eyes Intelligence Sharing Network. And what do we know about that? Not much, because it's secret, but we do know that there's vast amount of data sharing with the US. So Canada and New Zealand have been found adequate. They're also members of the Five Eyes. So to me that raises an immediate question. Are they also adequate? What about Israel? Also has been found adequate, but has a very strong national security state. So I think there are questions to be raised about other adequacy decisions. The contractual clauses or the adequate safeguards, there's an immediate question you can ask, because in the Schrems judgment, the court really put a lot of emphasis on the access to data by intelligence services. Can you protect data against intelligence service access by a contract? No, you can't. If you run up to the FBI with a contract and saying, stop, you're breaching a contract with David, I'm transferring data to him, they will just laugh at you. And the same is true with BCRs. So I think that these issues are the case there, and certainly with regard to derogations, the fact that someone has consented to a data transfer, again, has no effect on access by intelligence services. So there's certainly a question here which I think really gets down to the point, how much emphasis do we want to give to the fact that it seems that data in the internet can be widely accessed by a number of different intelligence services. The court in Schrems put a lot of emphasis on it. I'm going to leave this question open and get back to it a bit later on. And I'm going to now get to my conclusions, which are a bit long, but I think I can still finish within 30 minutes. I would say that the judgment demonstrates both the reality and the illusion of protection in the regulation of international data transfers under EU law. Certainly the reality is that the court has given a very strong affirmation of the fundamental right to data protection. And in the pantheon of fundamental rights, it's become, it used to be the kind of plain, orphaned child wandering the streets, and it's now been brought into the family of fundamental rights, and it has a full status, and that's good. But there's also a lot of illusion here. It seems to me that actual protection in practice with regard to data transfers is quite weak. But I'm not sure that so far there isn't really much evidence that we even care that it's weak. And for example, the Schrems case came down in October 5th, 2015. The court said this violates the essence of the right to private life under Article 7. You couldn't have a stronger affirmation there. How many enforcement cases have you heard of where data transfers have been blocked or have been restricted based on the Schrems, based on someone taking action based on the Schrems judgment? I only know of a couple in Germany, in different federal states, which are frankly not very impressive. So we have this strong affirmation of a legal right and we have no enforcement of it. That seems very odd to me. And it seems to me kind of showing this is a bit of a legal Potemkin village, I would call it. We set up this wonderful facade, but we don't really want to enforce it. And something's wrong there. When there's such a vast gulf between the written law and the actual way the law is enforced in practice, I think that this raises questions. And international data transfer regulation also relies very heavily on formalistic measures. The signature of contractual clauses, signing, when you go on and you want to buy something on some website or something, and you have to click a box saying, yes, I agree to transfer my data, etc. Lengthy approval processes of BCRs by DPAs. What does this have to do with data protection? This was brought home to me after the Schrems judgment in my limited time that I'm still involved with law practice, where we had a client that came to us and said, oh, now we have to change all of our contractual clauses. They have, some companies have hundreds of these contractual clauses to transfer data all over the world, and they said we have to make changes to the wording of them, etc. And I thought, what does this have to do with data protection? I mean, what effect will this have? These clauses have never been tested by anyone. Probably no one except maybe a couple of DPAs with whom they've been filed know they exist. And now we're going to spend a lot of time and money amending them. Okay, so what? What does this have to do with the reality of data protection? And it's very little, I think. So we have a huge edifice of formalism and sort of legal fiction in data transfer regulation. Another thing that's striking to me is that in the 18 years since the directive came into effect, there have only been 13 adequacy decisions rendered by the European Commission. And there are something like 215 member states of the UN. So at this rate, we'll be going for a couple of centuries until the rest of the world is found adequate. And by contrast, the Commission has made well over 100 decisions in the last few years, finding third country legal regimes equivalent to EU rules in areas of financial services regulation, such as accounting standards, statutory audits, etc. Why is it so difficult to reach these judgments with regard to data protection? Now, you can say, of course, data protection is maybe a particularly difficult area of law because it involves fundamental rights, and there are very differing views of fundamental rights around the world. But it seems to me that we've really, in some ways, reduced data transfer regulation to a set of formalistic and bureaucratic procedures. But this does not fulfill the standard the court set. The court said a number of times in the Schrems judgment, and has said it since in other judgments, that the protections for personal data must prove in practice effective to ensure protection. So, and we know this from the European Court of Human Rights. I mean, this is clear. You learn this in your basic human rights course. There must be an adequate legislative basis, but then it must actually be enforced in practice. One without the other is not enough. And I see the privacy shield as sort of mixing these two. There are some interesting mechanisms in it that could prove to be effective in practice, like having regular annual reviews between the Commission and the U.S. But there's also quite a lot of formalism in the privacy shield. I'm going to skip over a little bit here so I can finish on time. We also know that there is massive intelligence sharing. It seems between all countries of the world, or at least the Western countries. They just share a lot of data. And there's a disconnect between the adequacy judgments and countries that have been found adequate, there also seem to be very involved in these activities. It seems to me at the end, a lot of this really comes down to politics. This is when I had my aha moment, when I started reading writers who write sort of critically about human rights, because I realized this is really, if you look at this, it comes down to political factors, and the law is being kind of dragged along to give some window dressing sometimes. But a lot of this is really about politics. This area is intensely political. You can see this certainly in the EU and the US relationship, and I could give examples of that. Each side wants the other side to change its law. The EU activists say the US should adopt a data protection law like we have, and the US says, why do you have this strict data protection law? You're hindering economic growth, you're hampering the work of our intelligence, anti-terrorism agencies. There's nothing wrong per se with having political disagreements about data protection. And indeed, this is how in a democracy we we make law. But I think the problem is that it's very difficult to, and sometimes almost impossible to separate the positions, the legal arguments that are being made by each side from their underlying political assumptions. And each side simply ends up repeating their political assumptions, and it goes around in a circle. And that's why we don't really seem to make much progress in this. It just goes around endlessly. I think the privacy shield seems to be a kind of attempt to break out of this cycle. Frankly, I hope it is successful. I think we have now a couple of years to test it and to see how it works in practice, because even if the next Schrems 2 case does go to the court, it will take a few years to have a judgment, or if the privacy shield is eventually, some question about is referred to the Court of Justice, we won't know for a while. So this is the chance now to really show that we have real protection in practice. And if we do, then good, maybe we found an interesting new model. If we don't, it will be invalidated the same way the safe harbor was. I think this case also says a lot about the EU, the sort of global power struggle with regard to regulatory influence. This is really, the Schrems case reflects really an assertion of unilateral assertion of values by the EU, the same way that the US has done in many other areas of regulation. And I think that the law is given more weight than it can bear if we try to solve these problems purely through legal means. Because if they are political, then trying to find some magical legal formula to solve them is not going to work. However, the law can still, I think, make a valuable contribution to find lines of compatibility and communication between different systems. And I hope that we can start to move that way. I think what's important is that EU data protection law must move beyond illusion. We have to look the problems that data transfer regulation give rise to squarely in the face. And I think this means that we need real enforcement too, if the law is to retain its legitimacy. We have really two choices. Either the law is enforced or the law is changed. But I think we should all now say this has been going on for so long, to have very strict legal rules which are never enforced. Now this could cause disruption, of course, in international commerce, in international communication. But I think that being faced with these kind of situations could be a kind of crucible that forces the EU to make the necessary decisions, the realistic decisions made about how a system of data transfer regulation should work. So this judgment is a real boon, and to all of us in EU law, data protection law, we love it. It's been just like a Christmas has come early. It forces us to look at the contradictions of EU data transfer regulation squarely in the face. We can no longer ignore its legal and logical incoherence, nor can we pretend that a global regime of data protection can arise purely by formalistic measures. And I'm critical here of the EU, but this doesn't mean that I'm greatly enamored by the approach the US has taken too. I think the US and other third countries have a lot to learn also from their own with regard to the way they've been handling these issues. So I hope that all of this could help provide some common ground to overcome these illusions in the current data protection debate and bring it back to reality. So with that, I will stop, and I'm happy to have a discussion and answer questions.